What is your name? I filed by you. What is the IA regarding? Which IA? There's so many IAs. Yes. So you have got to file a reply there. Okay, Mr. P.K. Tiwari. No, Mr. S.K. Ghosh appearing for the writ petition praised for time to file uh, affidavit in IA Civil 1448/2024. The same is not objected to by Mr. Uh, by Mr. You Pathak, counsel for Learned Counsel appearing for Mr. P.K. Tiwari, senior counsel, for the respondent. Accordingly, this matter after 3 weeks. 3 weeks. Bad case? What? Why you're not in a hurry? Oh, that's why. Wait for the state. Oh, yeah, so 3 weeks is okay. This is the matter after 3 weeks. Hmm? You give a date. Interim order to continue till the next day. Yes. What is the matter about? Contract period is over. Okay, list the matter. Okay, huh? List the matter on the pair of Mr. M. Sarkar appearing for the petitioner. List this matter when? No, the other matters, what do you think? List this matter after the week. Okay, list this matter on Friday next, 15th. Interim order to continue till 16th. Okay. Hello, Station. Why don't you argue? What is your name? What is your name? R. Jubilee. Jugli. Miss R. Jugli appearing on behalf of Mr. Dr. B.P. Todi, Learned Counsel for the petitioner. Praise for adjournment. Who's for the other side? Huh? Have you taken the consent? And submit that she has taken the consent of the other side. Okay, then. Accordingly, matter adjourned for how much? How long? 1 year? Okay, for a week. Can they be? Adjourned for the day. Okay. Mr. R.M. Das, Learned Counsel for the respondent number 2, 3, and 4. For to do what? Adjourn for what? We'll adjourn it, but for what reason are we going to adjourn it? To enable him to produce some documents. The same is not objected to by Mr. Your name is not here. Your name is not here in the call list. This is the blacklisting for case. Okay. Same is not objected to by Mr. S. Sharma, learned counsel for the petitioner. Acha, in that other one, I said respondents 2, 3, 4. No, don't say, just say respondents. So all the hearing matters are adjourned. Release the matter. When do you want? No, you give me a date. Okay, give September first week. It is with regard to that third party. So what has happened? Then who is who? Then what has happened? Item 13. Who is taking? And actually, but we have, I think, stayed any further lifting, no? But you want to adjourn it? Okay, right. On the prayer for adjournment made by Mr. K. Kalita, learned counsel for the petitioner. When do you want? Okay, on the prayer made by Mr. K. Kalita, learned counsel for the petitioner, which is not objected to by Mr. C.L. Agarwal, appearing for respondents 9, 10, 11. This is the matter on 16th. Next week or week after that. What is the matter about? He's not following the order, then you go and complain to him. Anytime. Ha. Liberty? Yes. Just show me. Huh? Probably that is the problem. Next time we should tell them to deposit here. But this is Nandlal Sharma. Acha ji, Mero Traders, yeah. But what about the other one? Juria Ready Made Center? Pay the money to whom? So who is this Juria Ready Made Center? Okay. So where is the Juria certificate? So that is required. No, no, but then anyway, it's a public utility, so. What is going on, Mr. Madam? This is not done. How much was the amount claimed in the item 19? And item 20, how much is the claim? No. No, but I don't understand this order. It says here, received with thanks from Assam Government Marketing Corporation Limited, a sum of rupees 47 lakhs. White check number so and so against our bill number dated nil, amounting to rupees 3 crores 95 lakhs. Okay, as full and final payment. No, but then that is only for Mero traders. Now, what about this Julia ready made? Assam Government Marketing Corporation not made a party here. Yes, yes, give me that. No, no, I've got the repetition orders here. Yeah. Mm. Yes. Mm. Ah. Why didn't you make this? But where is your senior? What's his name? Huh? Tell him to come. We'll take it up. Let her senior come. At 2 o'clock. CBT promotion. Huh? Huh? For, for what? For what? Where is the NIT? Let us see the NIT. dated 15/5. So this supply for what? Dietary articles. Group A. For which place? Observation home at Boku. Only for Boku, nothing. And what is the for and this is for which period? 2022-23. So when does that end? Let me see. Where is that page? Page 27. Date of agreement dated cannot be. Mr. Counsel, at page 26, it says an agreement made on this 21st day of July. How can it be 4th of June? The agreement valid till the tender for the financial year 24-25. That means it is valid till 31st March. Huh? Is it? Where is this is the original version, translated version, or what is this? Thirty-one. This agreement valid till tender for the financial year 24-25. Okay. So till the tender for 24-25 is complete. For Boku. Yes. There is something wrong with this thing. Page 26. This page 26. In bold, in the first paragraph, you see, for the financial year 23-24, with effect from 1/6/23. So it should have been only till 23-24. Now, however, clause 9 provides that it will continue till the 24-25 of because As per this, let us see the NIT again once more. What is that? NIT page 16. That's what. I think that must be I think a typographical mistake or something like that. Correct, correct. Huh? So you see, there is one thing. You see, you obtain instructions as to whether subsequent to this NIT at page 16, a subsequent NIT has been issued or not. If it has been issued, that's a different thing. If it's not been issued, then he should continue. Because clause 9 of the agreement provides that. When can you obtain? Where is the, no, what is the, there is no supply order issue. Okay. This is 26th July. Now is what date? Huh? 8th August. More than 2 weeks have gone. No, nearly 2 weeks. Okay, no, he's supply. He's supply. There's need. What note? Yes. We'll list it tomorrow. You obtain instruction. Okay, right. Right, Mister. You Datta, learned counsel for the petitioner who submits that pursuant to the notice inviting retender dated 15/5/23 for supply of dietary articles group A to the observation home Boko, Bamuni Gaon. The petitioner was selected as the successful tenderer. In terms of the agreement dated 21/7/23, executed between the respondents and the petitioner, comma, the petitioner was to supply dietary items to the observation home Boko Bamu Ni Gaon for the financial year 2023-24 with effect from 1/6/2023. However, clause 9 of the agreement provides that the agreement would be valid till the tender for the financial year 24/25 has been completed. The grievance, next paragraph, the grievance of the petitioner is that despite clause 9 of the agreement mentioned above, comma, the respondents have taken a decision to allow the respondent number 5 to supply dietary items to the observation home Boko. Even though no NIT has been issued for the same, subsequent to the NIT dated 15/5/2023. Huh? I know, but for Boko, no, that's what I'm not on that. For Boko, you're the one who said it. So that's what. So I just want to know whether any list the matter tomorrow. Tomorrow list the matter tomorrow. You mention it. You mention it. We'll just say tomorrow. Extra copies tomorrow. List the matter. List the matter tomorrow to enable Mr. K. Gogoi to obtain instruction. Item for what? Is there any arbitration clause? Then fundamental irregularities can always be challenged in a arbitration. Huh? What can be filed? I'm not saying that it cannot be filed. You have filed it also. It can. You see, you're talking about judgments passed in Tantia construction probably. But then that is also subject to various other decisions, like in Whirlpool. Uh-huh. Correct. Where is the arbitration clause? And it is a faster process now. 2019 matter. It has been stuck here. The last, I'll just the way it has been listed. 2019, it was listed once. 20 twice. I mean, then 2022 listed once. 2024 listed second time. Unnecessarily pending here. But if you had gone for arbitration, it would have been finished by now. Heard Mr. S.P. Roy, counsel for the petitioner, and Mr. B. Sharma for the NF rail. The petitioner has prayed for refund of the security deposit, performance bank guarantee, and the vehicles, including machineries, which were utilized for performance of a contract in pursuance to where is the NIT? In pursuance to NIT dated? Huh? In pursuance to NIT, in pursuance to a tender document issued by the Northeastern Frontier Railway for garbage-free maintenance of railway colony in Maligaon area. 21 2001-2015. The petitioner had been awarded the contract. However, the same was terminated. Wide order dated 10/3/2017. Page. Wide letter dated, huh? 10/3/2017. Uh, what's that? The petitioner was also debarred from participating in the tender for executing the balance work and his security deposit and was forfeited, correct? And bank guarantee was encashed. Okay. Performance guarantee. Performance guarantee was encashed. Performance guarantee was guarantee was not returned, was not refunded, was forfeited, was forfeited. Full stop. Next para. The Mr. B. Sharma, the learned standing counsel, NF Railways, submits that the contract in question was terminated by following the due process of law, wherein the petitioner was given adequate opportunity of being heard. Full stop. Huh? Due after being given due notices. He also submits that as there is an alternative dispute resolution mechanism by way of arbitration in terms of clause clause 15 of the contract agreement, comma, the present writ petition should be dismissed and the petitioner should avail of the arbitration clause. To stop the counsel for the railways for the submit that there are disputed questions of fact involved, and as such, the this court would not be able to decide the issues pertaining to disputed questions of fact. So, sir, the petitioner's counsel also submits that the termination of the contract has not been put to challenge by the petitioner in the present writ petition. So, sir, next, on considering the submissions of the parties, this court is of the view that as there is an alternative dispute mechanism for resolving the dispute between the parties, the petitioner should avail of the alternative remedy available. Full stop. Clause 15 to clause 15, huh? The clause 15 of the uh, contract agreement executed between the parties states as follows. Huh? Take it up. Page 67, 68. Next, para. In view of there being an alternative dispute mechanism, the petitioner should avail of the arbitration clause to put a challenge to to put to resolve any of his grievance, including termination of the contract. Full stop. And the party should also consider the question. No, no, no need. That's all. Because limitation will arise, but then you can always mention this pendency of this writ petition. No, no, I cannot do that. I, that is, I've given you liberty to do it. I, you have to avail. I cannot ask you to go and do it. I am not a party to your dispute. I'm giving you the liberty to do it. Only thing is that when you do it fast, because the question of limitation come, but limitation will go because section 14 of the Limitation Act is there. So that will not stop you. Okay. All right. Whatever I said. And stop in view of the real state above, comma. The writ petition stands dismissed, comma, with liberty being given to the petitioner to avail of the arbitration clause, if so advised. Thank you. How long will you take? How long is this matter going to take? First of all, I think we'll do other matters first, yeah, because otherwise, you wait, you will see. We'll take other matter now. Are you free? There's some technical. Huh? No, no. What is the issue here? Who directed you to? Where is that? Where is the direction? How much I suppose? Yes. Yes. Remaining part of the what meaning? That 1 lakh something was not paid. Actually, it accrued to 10,30,721 as on 19 Feb 2016. 2006. Then, so they paid you how much out of this? 39. So balance was then. So when the court is saying to implement the remaining part of the award means this balance amount of 8 lakh. The amount and principal. The amount and the principal rose to how much? How much? 7,200 and 465. Huh. 39 lakhs, 92,000. How much? So, my God, the interest, everything is interest. From 1 lakh, yeah, it has gone up. The problem is sometimes, I don't know, maybe y'all have got some good friends in the government also. Huh? Delay payment, and then better to put it, better not to pay it instead of putting in the bank deposit. But if you put in the fixed deposit, how much would you have got? Very less. What is the interest you get to pay this? No, no. So 39 cents so was paid. So altogether, the 2 lakhs balance is there, approximate. 2 lakh 14,000. That too has to be deposited as tax. As what tax? What tax? TDS. Okay. So this 39,92,940 is supposed to be the total final bill. So okay. No, no. So this 39,000 was paid. 39 lakhs was paid when? Huh? Date. 21st of January 2021 has been paid. No, no, just a minute. Now what are you claiming out here? Okay, this 39 lakhs was due to you in 2015. So you are claiming interest from 2015 to 2021, amounting to 70 lakhs. 70 lakhs, 54,000. So your initial claim was 1 lakh thing, and you are now, my God. Okay. So everything is according to you, money, money, money only. Dollar signs. Huh? Yeah, yeah. Your entire life is only about dollar signs. Huh? Yes. Yeah. Hmm? I will wait for Mr. Gogoi. Next. Report. 8, they have not filed affidavit. Yesterday, they filed. It's not on record. Oh, what is he giving me? I don't know. Huh? This is which item? Item 4. No, item 4, there is nothing. Item 4, there is no affidavit. So right now, this is item 4. Item 4. Mm. It's the same thing with it. Okay, right. Third, Mr. Huh? 4. Jay Barbuya, Learned Counsel for the petitioner, and Mr. M. Chetia, Learned Counsel for all the respondents. The petitioner claims no, the petitioner's prayer is for payment of the hiring charges of his vehicles amounting to rupees. Mr. M. Chetia has submitted letter number KNZ-1/2024/369 dated 14/5/2024 issued by the Additional District Commissioner Pokrajhar, which states, which has been addressed to Ms. Usha Das, Additional Senior Government Advocate, Assam, Guwahati High Court, which states in para 2 as follows. Take it down. The letter dated 14/5/2024 is made a part of the record. No, before that, no. The letter dated 14/5/2022 also contains, or no, also No. Next, don't say anything, just write next para. Mr. M. Kshatriya has also submitted a letter dated. Huh? This third page is for what? Same. Actually, it's not for his only. Okay, don't say that. The letter dated 14/5/2024 is made a part of the record and marked as Annexure X. Huh? As the claim of the petitioner for payment of outstanding dues amounting to rupees 11,69,51 521 for hiring charges of his vehicle, vehicle actually, one vehicle AS 16C/6749 is not disputed. No, is admitted by the respondent authorities, comma. The respondent number, the respondents, comma, especially the respondent's number 3 is directed to pay to the petitioner the admitted amount sub no, to say the respondents especially. This is the respondents are directed to release the sanction the funds and allot the same for payment to the petitioner within a period of 3 months from the date of receipt of a certified copy of the sum. The writ petition is accordingly disposed of. Then next. Okay, right. In item 5, out here you say, out here the amount will be 30,67,488. Claimed amount. Then the affidavit in opposition filed by the respondent number 3 on 31/5/2024 has admitted that the petitioner's vehicles had been utilized for vehicles or vehicle? One vehicle. Vehicles had been utilized for had been hired by the respondent authorities, and that the hire charge the bills for hiring charges received from the petitioner had been forwarded to the concerned department for necessary sanction and release of funds, and that further payment would be made on receipt of funds from the government. Para 3 of the affidavit in the possession of the respondent number 2 is reproduced here in below as follows. Page 80. Next para. Injury of the admitted. Same thing. Okay. Then item 6. In 6, it is 25,053,315. 25,53,314. Okay. Same thing. Okay. Everything is same. Then 7. Okay, right. In para 7, you say M. Chetia is granted a week's time to obtain instructions and file affidavit in if necessary. List the matter. Where is the affidavit? I don't have the affidavit. Yeah, file. Okay. Okay. All right. Out here the amount is 12,07,196. Huh? Same paragraph, paragraph 4. But same thing. Is it the contents are exactly same? What do you mean almost same? It cannot be. It has to be same. Otherwise, there will be a problem. No, it's not same. You check. You take a photograph of this. Better. I will keep this. We'll keep this with us. Yes. Okay, para 4, huh? Para 4, 4, 4, 5, 6, and 8. Except 7 we have disclosed. Yes, who's appearing? There. So according to you, how much is the admitted amount? How much? As per your affidavit? Affidavit of respondent number? Yours for 4 and 5. Huh? Affidavit deposition filed by the sole respondent. Kasturi Bharati. Page 38. Huh? Where are you reading? Page annexure 7. 38 is annexure. Annexure, which annexure? Annexure 7. Page 38. From where? From where are you reading? Which line? Chart is there, yes. हाँ 00845598 ठीक है. This 81, these 281s and 191 and 41. So this 4 lakhs 12,000 is not accepted, not admitted. And that 2 lakhs 47 also is not admitted. So yeah, from 81, this I mean 6 lakhs, the 19, 21, 21, 22, 22 lakhs something. But you're asking for allotment of 24 lakhs. Huh? Payable, huh. Where have you said that petitioner's claim is admitted to the amount of rupees 22 lakhs? But this does not show that you have admitted to 22 lakhs. Huh? So that 22 lakhs has to be paid. Where is the senior? He's on legs or some he's waiting for his item. He's on legs. Who's the senior? Let me wait. Huh? Let him come, we'll see. We'll see. Huh? No, no. Acha, there's no other matter. He's young, old, doesn't matter. That IA was disposed of already. Actually, last time when I checked, that order disposing was not there. Last night when it was again listed, I checked again last night. Along with the no, it is there. Then the disposal order I found. Contempt has been restored, but the IA has not been restored. That's the issue. Ah, IA should have been restored also. IA for what? Okay, we'll restore this IA also. We'll have to restore. Because the contempt was, that order was, where is the order, setting aside the order? 5 to 20. Okay, right. This contempt petition, I heard Mr. A. Boro, huh? This contempt petition had been closed, wide order dated 5/2/2024, on the ground that it had become infructuous. So stuff. However, wide order dated 24/7/24, passed in IA Civil 710 SAC 2024. This court held that there was a mistake committed in closing the contempt, and as such, this court had recalled the order dated 5/2/2024, passed in contempt case number 700 of 2022. As such, this contempt has been listed again before this court. However, the IAC 2596 of 2023 has not been listed again, even though the same had been disposed of in terms of the order dated 5/2/2024, passed in the main contempt case. As the order dated 5/2/2024 in the main contempt case has been recalled, the said order cannot be made operative in IAC 2596 of 2023. Consequently, registry to list IA 2596 of 2023 as the closure of IAC 2596. No, in view of the in view of the order closing IAC number 2596 of 2023 has been recalled. List the matter on Monday. Huh? Tuesday. List the matter on Tuesday. Then also in the thing, and I think item 11 also will have to be. What the same thing happened? No, I think it's different. Item 11. Item 11. Ah, actually, this I again have said again they have listed. The disposal order was there. Who was supposed to file the additional affidavit? Who is the respondent? Huh? This is a contempt case. Narayan Das. They're not here. What to do? You call them? They should be here. Huh? Well, So we made the correction of the address. Right, Mister? Your name, Vedas, learned counsel for the applicant who submits that the applicant read petitioner's name, applicant slash read petitioner's name, address has been wrongly typed in the cause title. He submits that instead of the address of the applicant slash read petitioner being typed as so you take from here, huh? In the as so and so, as so and so, it should be typed as so and so till here. Okay, it is in this 2 pages. Huh? Okay, yes, sir. Mister, yes. What is your name? A Ali. AI Ali. AI Ali. Let's answer for the response number 2, 5, 6, and 7. Anybody else? Mr. K. Gogoi for 1. Are you there also? Yes, Mister. Are you there? And G. Sharma for 3. They submit that they do not have any objection to the correction of the address of the applicant slash read petitioner being made. Accordingly, the prayer of the petitioner's counsel, accordingly, the application is allowed. Applicant to submit a corrected slash amended copy of the cause title to the registry within a week. I is accordingly disposed of. Then you write in the main case, in view of the order dated 8/8/2024, passed in IAC 2249 of 2024, the address of the writ petitioner has been corrected as so and so. Huh? This, what are you? You have to file affidavit. Oh, main case. Uh, don't say that corrected copy is required. Huh? The I is accordingly disposed of. Huh? No need to make case no order. Item 2. Yes, item 2. Yes? Kaline. SPC. P. Which petrol pump? Kaline. Teacher. Just a minute. Whether IOCL has In the letter dated? Why? This is the main thing. Oh. It'll be difficult to understand the letter. Who are you? You're the brother, sister, or you should have made a chart, family history, family tree, page 236. Just just page 236. Yes. So this is the family tree. He's your father. He's a Sikh or what? Oh, he's a Hindu. They're Sikhs. They're called Singhs also. As per the- So what? We are going into Hindu law out here. Well, I thought maybe we'll have to go to that Mitakshara and all that. Third wife has got 4 children. Prakash Singh is the petitioner here right now. Petitioner and proprietor of the two Sharma and Company. That means of Kalayan and the Silchar. This, uh, but why is it written in the chart petitioner Sunita Devi Shore is the petitioner? Huh? So out there in the if it's a civil suit, there will be plaintiff, they will not be petitioner. Huh? She's anyway, there is a civil suit pending. Okay, that civil suit is pending between you and your sister. Yeah. Good. So is lawyer's paradise, is it? Anyway, okay. Anyway, so the altogether there were five petrol pumps. Yeah. No, you tell me, what is the issue in the broad? Can you just tell me what the line, and that is being run by you of the second wife. I have to for the time being, otherwise if we. You said to you and your mother. Correct. Who is giving a share? Okay, the sister. Given a share of what? Of the Kalayan and Sister, no. No, one thing. See, first of all, that partition of 2006 was made between whom? Hmm? And the mother. And your mother. Okay, so this is the first wife, second wife, and the children of the second wife, they're not involved in this case. It's only between the third wife and the children. Okay, now those three other petrol pumps have gone to the other side. All the your home. So according to you, he has got only one petrol pump. According to you, maybe there's Kaline and Silchar. So you have got, according to you, which one? None. He goes to the other side. Okay, okay. So you have been given one petrol pump. So Jaiprakash has got two left. So now you want to come into his share. Okay, let me hear. We'll go through that. We'll go through that. That and this partition deed was signed by whom? Who? Acha, this Sunita Devi was not there. How come SPC? Acha, your name is SPC. NOC given by whom? Now, what is the basis of of the sister's claim to a share? So that issue is that issue is before the civil court. Whatever it is, what is the basis for her claim? I just want to know. What is the basis for her claim for a share? MOU, so what is to be decided here? No, no, what is your prayer here? Reconstitution of what? This MOU is what? What is this MOU? Signed by whom? To, and that MOU was in your favor. With regard to the petrol pump? So there was so was it mentioned in the MOU, the petrol pump? Yeah. Okay, so he now now the response your sister is denying that she signed it or what? MOU. Okay. On what ground? On what ground? Okay, just let me ask. Are you challenging the MOU signed by you? You give a copy to your friend also. No. I just wanted to clarify some small doubt. So the MOU, you're doubting, have you not challenged it? What partnership? There is no partnership. You have not talked about any partnership. Partition, so that's a different thing. There's no partnership. When did the petitioner start running the petrol pump? Since when? Hmm. Anyway, let me hear the petition. Everything according to you. Yes. But you give me a copy. Better, because then I can maybe underline, make notes. Yes. Yes. Huh? Paragraph 2. Okay. Yes. Can there be a partition between the mother and son only? Can there be a partition between the mother and son only? No, but then we just want to know. No, no, it has been acted upon, that's a different thing. Can doesn't the daughter also have a right to the share? And I think there was an amendment made, no? What about the other two sisters? They're not claiming anything. I understand. I mean, that will be his argument too. I think that is the way his argument is going to go. They will be doing that. That is what he's trying to do. This civil suit was filed when? Do you need to be a party? Okay. Do I have a choice? No, no, you can carry on. Doesn't matter. Why are you jumping? No, you not want to pet three. Yes. Let me see this MOU. Where is this at page? Have they said that all the properties are being decided or something? Where? Yes. What is the holiday scheme? Example. Call. After 5-10 minutes. Yes. Yes. Hmm. Yes. Gmail. Yes. It's two 278. Okay, 279. Ah, yes. What do you mean by nominee out here? What is the nominee's role? No, 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 no. When a petrol pump is it given to a nominee or is it given to a dealer? Or how is it? It's given to a dealer. But this talks about induction of a nominee. Nominee. I don't know. Let us ask. What do you mean? What do you mean by this dispute in case of induction of nominee? So the petrol pump is given to a dealer or to a nominee? Then this one is a sole proprietorship. Yes, yes, correct, correct. How is it? How is it become a partner? Where? Where do you get that? I don't know. Huh? No, no, you are saying that this G9 is not applicable. Then what are the first point you said? Ah, ah. Yes. लीगल है तो शी इज लीगल है. हाँ. हाँ. So your basic point is that since the issue of whether she should be an inductee or have a share in the property would depend upon the decision to be taken by the council. That's all. No, what are they going to do with the write the impugned letter? They are going to take over the assets or what? How can they take over the? That's a different issue. What is the reconstitution that they keep on harping about? Is there anything out here in the guidelines? Okay, one thing, dealership name. Yeah. So it is still the dealership name of. Huh? Since? Yeah. No, no, we are talking about the name. Yeah. That's what I wanted to see. 261. Anyway, 1 o'clock now. I don't think you're going to finish very fast. This case. No, no, I know you're not finished. I'll give you a stop clock. Stop clock. You will finish. Anyway, what we'll do is at 2 o'clock we'll finish off the other matters first. Then we'll carry on. Hemdas appearing for the petitioner and Mr. Ardhar appearing for the respondent. Sub appearing for the no, what finance? This is a contempt. Okay, just Mr. Ardhar and Mr. For the Mr. B appearing for the respondent submit that the order has been complied with. Accordingly, the contempt petition can be closed. To stop in view of the submissions made by the counsel for the parties, the contempt petition stands closed. In both the writ petitions, same order. Timing tree. Yes. Huh? Okay, okay. You're that person who has become a millionaire due to 1 lakh, 1.5 lakhs. Now what to do? Of that period? Okay. Now this is a this no, this is what? This is a writ petition. I think we'll take it up after some time. I will. After the Independence Day. What? What? Only thing is what? Where is that note I made? Just let me see. Even I'm thinking of that. Let them go to civil court. I think we should go to civil court. That is not an agreement. That is a request. Signed, but the request has been signed, not an agreement. That does not. Just because the request has been signed doesn't mean that it has been. Huh? Now, where is the note I have made? I'll list this matter again after the thing. Because I'm hearing this. List this matter again after the thing, after independence. Huh? Huh? Can it? Item 9. What is this matter? No, no. So you have not paid. You have claimed how much amount? Page 16. Page 6. Page 16. Yes, yes. Okay, okay. So the amount is already here. Okay, this is the petitioner's claim. To verify the claim, and now they have verified it. Of the page 38. Huh? I know, but the problem is I again have to look for this page. Page 38. Page 37. Huh? Where is page 38? The 38 is what? This is whose affidavit? Huh? Your affidavit. Okay, by sole respondent. Huh? Yes, correct. That you'll have to pay. That they will pay. For the others you go. I don't know. I'm not on that. I'm not on that. I'm not going to go into the merits of. Uh, heard Mr. S.K. Das, learned counsel for the petitioner, and Mr. S.P. Das, learned counsel for the respondent number one. 1, 4, and 5. Who appears for 2 and 3? Mr. R.K. Dev Chaudhary. Mr. R.K. Dev Chaudhary appears for respondent's number. Respondent number 3. Mr. S.K. Das, learned counsel for the petitioner, submits that the order dated 30/07/2021 passed in WPC 4709/2020 has not been complied with, inasmuch as, a direction had been issued to the respondents to verify the claims of the petitioner and to make payment of the admitted dues payable to the petitioner. The petitioner's counsel submits that the petitioner has dues were rupees 38,33,500, out of which an amount of rupees 6,72,672 had been paid. However, the remaining balance of rupees 31,60,828 had not been paid by the state respondent. Next paragraph. Mr. S.P. Das, learned counsel for the respondent number 1, 4, and 5, submits that on verification of the dues of the petitioner, it was found that the petitioner was entitled to the payment of rupees 22, 44, 000. And the and and that the reason for the same is provided in the order dated 13/7/22 issued by the Director, Employment and Craftsman Training, SM. I have heard the land councils for the parties. As the respondents have admitted that the petitioner is entitled to the admitted dues of rupees 22, 47, 0, 44,000 000. The respondents are directed to make payment of the same after obtaining the necessary sanction and funds within a period of. Acha, naturally, sanction funds after. I've said you have sent the proposal, you have not got the sanction. So I've said sanction and funds within a period of 3 months. 3 months from the date of receipt of a certified copy disorder. Acha, before that, before I have heard, Mr. SP Senso has also submitted that a proposal has been sent. But this is for 24 only. Huh? Acha, has sent a proposal to the to the to the just a minute. Mr. S.K. Das Leonard Council, no, SP Das Leonard Council for the respondent number 1, 4, and 5 submits that for getting the sanction and funds for payment of the admitted dues to the petitioner, supplementary demand proposal has been made by letter ECF number DCT/477-556/1/67447/2024 dated 7/8/2024 issued by the director by the respondent number 5 and addressed to the respondent number 4. The said letter is made a part of the record and marked as an extract. Then in view of the huh? Acha, okay. With regard to the disputed amount, the petitioner is given the liberty to approach the civil court as per law. The writ petition is accordingly disposed of. But then actually it's not that. When the usually contracts are given when the funds are in hand, or if it's going to, they're going to come. Most probably the funds have come, you have utilized it somewhere else. No, that is only from last year, from that ISMIS, from that ISMIS method of accounting. Now you cannot, but 2, 3 years, 4 years back, so it could all be done. It's only last 2 years this thing has happened. That is before. That is now. The funds cannot be given now through this way. Is the correct way because the state governments are not paying. They're utilizing the funds elsewhere because of your fault. 11. Item 11. Yes. They want to file? Okay. What additional affidavit do you want to file? Huh? Let them say what they want to say. Why are you saying for them? You're causing confusion. Huh. Now that IA has been disposed of, I don't know how it was disposed. Okay, it's disposed of. Where is that IA? Yes, we can go. Give me that IA. 2053. You see, this IA, that is for implement of Bhaskar Jyoti Sharma. What I'll tell you what it reads. Mr. S. Chamaria, learned counsel appearing on behalf of the applicant, submits that he would not like to press the instant application. Accordingly, the instant application stands closed on withdrawal. 19/7/2024. So you file a fresh application. This has been disposed of. This is disposed of. What to do? Yes, what do you want? Okay, no problem. Mr. ML, MM so learn counsel for the petitioner submits that he will be filing an application for impleadment of the present incumbents. Accordingly, release this matter after 2 weeks. I don't need this. This will be thrown away. Yes. Hmm? How was it given to you? Was your name inserted somewhere in the thing, or is it still in the name of your grandfather? The dealership, huh? Sharma and Co, but it's a proprietary firm, no? Then no. So Sharma, so your name has been inserted in place of your grandfather. Is that correct? Oh, then when was it inserted? Your name when? Huh? 98. Petitioner's name inserted as proprietor of Sharma and Co. on you see, when was the petitioner's name inserted as the proprietor of that Sharma and Company? So that you see that person died in 19. When did he die? Died in 1967. Okay, and they have not changed. Which date is that? Partition is of 2006, you said. Then this is the audit is of 2009. Where? License? Okay. Anyway, so you were running the petrol pump since when? Since when, madam? Kaline is when? When was inception is when? 1973. So from land was Indian. Then Silchar. When did you start running it? He died. Yeah, correct. Helping him. Uh, from partition it was you only. November, that is not the date. Reconstitution under what provision? Show me the guideline. Yes. No, you see, reconstitution would basically mean, I think, who would run the retail outlet. Naturally, who would run. Now, how do you do that? How do you, the dealer died in 1967. That when did you make this request to them? Only in 2014. Okay. When okay. Tell me one thing. A person, there's a okay. So when the dealer dies, you want a reconstitution. Where is the provision? Show me, no? Show me. Show me the operative portion. Naturally, this is a commission case. This is a case where the petrol pump is already commissioned. Page. Where reconsider commission? Yes. Page. Yes. Now in this case. So yes. Now, now the issue here is that person died in 1967. No, no. So no. So if his legal heir was running the entire thing and there was no dispute, why wasn't it reconstituted in the name of the legal heir? Oh, say that. Now reconstitution policy. You see, this reconstitution policy came into effect when? Yes, when did it come into effect? Additional guideline for reconstitution, 21 May 2013. Now, the this G9 or whatever, is it part of the reconstituted edition? Is it part of the additional guidelines? G9 and 10 both. Okay, wait. Let us go to G9 first. Does it, what does it talk of? It talks about induction of nominee, legally family member, amongst partners. So out here there is no induction. Is there any induction right now? On what basis? On what basis? Now, the issue is, supposing I write a letter to you, I want to be a part of it. Are you going to write a letter on my behalf, or are you going to decide whether I am a part of their family? Uh, who- so that issue, okay, you have got to decide. Where does it say that you have got to decide? Where does it say that you have to decide? Who are you to decide this issue? It is your dealership. Correct. And petrol pump is not your petrol pump. You're only supplying the petrol. You're not supplying, the land is not yours. So the court has no say in this. According, huh? Huh? You see, now there has been a memorandum of MOU signed. Who is to decide that, you or the court? That is not her. That is not the job of you to decide whether she agrees to it or not. When there's a memorandum of understanding which has been brought before this court for it to decide on that issue, are you the authority to decide? I'm sorry. I do not agree for at all with your answer. Just a minute. I'll get to it. Don't worry. What you're trying to say is at the end of the day, you'll decide everything. The partition, memorandum of understanding, everything. That the court will decide, not you. No, no, the leadership to you'll decide maybe, but on the basis of the decision taken by the court with regard to the memorandum of understanding and the other things, you cannot. Supposing you take one view and the court takes another view, then what will happen? That is why I'm saying I'm not going to decide that issue. So why should? So the question is, why don't we wait for the trial court's decision? Because you see, you might be taking one view that because of this memorandum so and this partition has to be read this way. But the trial court says it shall be read this way. So are you overreaching your jurisdiction? Because this is a issue with regard to shares, which has your only issue is with regard to oil, nothing to do with shares. Anything? What else? What else? What is your submission in this case? Opted for. No, what happens in the holiday scheme? If they cannot, if they do not, if there is no settlement, then what happens? You cannot run the petrol pump. You can take away your stuff. You cannot use that land. Okay, just sign the agreement. Ah, but this is not your. Is this your land? You see, first of all, that Kaline is his land. That is what you said. How can you say that you can take over that land? It belongs to the petitioner. Show me the policy in which they agreed to hand over the land to you for Kaline or for Silchar in the event that some dispute among the families could not be resolved. Is there any document with you? No, because we are saying something. Now I've got to take all these things into consideration. You have the you see it's okay for you to say there are some policies and there are some agreements, but unless I can see it in black and white before me, I cannot go in and take a decision on speculative submissions. There has to be there in black and white. So if you can show me that, you bring all the records. You bring the records then because I have got to see. Look, whether you see, the thing is that if I have got to decide the issue, I have got to go to the core of the issue. I cannot do it halfway. Now I haven't even heard him. I'm only hearing her. And petition, the queries that are coming out pertains to what I've heard from the petition. So now, from her submission itself, I want to see some documents of yours. Now, what he's going to say might throw up few different type of questions, for which again I'll have to ask you also, because the thing is that right now, it's your letter that is under challenge. So yes, so now I'll have to see first of all also whether even if the writ petition is dismissed or allowed, whether you have a right over the land of the petitioner, especially Kalain, when it is his land per se. So I want to see those documents. I'll hear him also. But then at the end of the day, unless all the documents are here, there's no point deciding an issue half baked, you know. No, let me hear him then, otherwise there's no point. Let me have an idea whether uh, how the how the case is going to unfold. Release from it. No, no, malpractice is all right. Malpractice is all right. You see, malpractices affect you. This doesn't affect you. Ah, that's why I want to see. I want to see your agreements. You see, you got the land because probably of some agreement. Now I want to know what agreement you made in 1940. Ah, and what agreement you made with respect to Kalain in 1973. There's a pending writ petition. How many writ petitions are here? So that will have to be heard also together with this. No, no. So that will have to be heard also. No, no, but then it has a bearing, it will have a bearing on this case also. If that is decided separately, then it will have a bearing on this. Correct. Blood, it doesn't appear to be so here. I would say must have been watered down quite a bit. Otherwise, you'd have had some kind of agreement by now. In page 235, 235 of the writ petition. 235. It's true for you, yes. 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 But you are not partners. Okay. They have the love in favor of legalization. Yes. Yes, they were 258. Yes. 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 So this same the order here, impugned letter is dated 19. So okay, so this impugned letter was not it. Yes. Okay, streamer.
Page 86, my lord. IOCL has written them subjects judgment of Honorable Guwahati High Court dated so and so in the matter of dealership of late so and so. Kindly refer to the judgment by Honorable Guwahati High Court dated so and so along with so and so in the matter of dealership. Thereafter, your also may skip over. You next page 87. You are well aware that corporation has afforded you several opportunities to resolve this impasse, including a joint meeting convened by IOCL at Guwahati on April 29th, April 2017, amongst the legal heirs of BNC. However, till date, we have not received any reconstitution proposal which is completed in all aspects, in spite of the various reminders given to you, including the discussion held on so and so. Under such circumstances, in the line of judgment so and so, please consider this as the last and final opportunity given to you and to submit reconstitution proposal in proper format so and so at so and so that from the date of receipt of this letter, failing which it will be construed that submission of reconstitution proposal for the said solution line with existing reconstitution policy guidelines of the corporation will not be possible for your end. In such eventuality, the corporation will initiate action as per prevailing policy, which includes suspension of sales supplies of the agencies immediately thereafter on the ground of non-consensus amongst the legal heirs, leading to non-conformation of the corporation's requirement for the subject of reconstitution. Thereafter, they again approach this honorable court that you will also will find at page 88. And this honorable court, my lord, tried to settle this issue again, page 93. And under the, my lord, leadership of the senior counsel, M.K. Chaudhary, my lord, one mediation, page para 7, you will also will see, page 93. Page 93. The family members have agreed to make an earnest effort for settlement and make themselves available on in the Nunnmati office. The court requests Mr. M.K. Chaudhary as a counsel for IOCL to guide the negotiation. Page 93. It must, however, be understood that parties must proceed without past prejudice and their efforts should be constructive and not destructive. So this court, a number including Apex court, tried to resolve the dispute, but it couldn't, my lord. C.A. Prakash Singh was not there. In that day, he didn't turn out. Thereafter, my lord, Final order was passed by this honorable court. Page 97, my lord. Not. No, this is. My lord. Again, my lord, page 106 is the operative part, my lord, after recording submission and all. By referring to the scheme so and so, Mr. Singh, senior counsel, taking note of the submissions made by page 106, my lord. Now the parties, in view of the consensus evolved at the bar, writ petitions are disposed of as infructuous by granting leave to the parties to approach this court if so as by in the event a fresh cause of action is ordered. The writ petition is disposed of with the expectation that both the contesting party would render necessary cooperation for IOCL. Thereafter, my lord, holiday scheme. My lord, I have given short brief note, your lordship. And it's on this thing that after this order, my lord, will be independent from because my lord, there.
No, you see, you see, now the problem is your subsequent letter. You have asked to hand over operation of the outlets along with all assets. That is a different cause of action which was never an issue earlier. You see, I can understand your point of view a little bit, but the problem is now your letter has its earlier your letter was stoppage of the supplies, termination, but now you have gone further. You have said that you will take over the operation and you will take over all the assets. That's it. Now, what do you mean by assets? You have to clarify that. You cannot take over his land, the Kaline land. When Kaline land is not your land, it is their land. You have to clarify those issues. All those things have to be done.
Otherwise, my lord, apex court and different high court also says that policy is, my lord, under the grid of my constitution, it is mandatory, your lordship, and undisputed. So policy has to be adopted. And here, my lord, from assuming, my lord, 14, I have given complaint. From 14, my lord, they are earning from that petrol pump, your lordship.
They are earning from before that.
Before that also, at least assuming for the sake of argument, 14, I came to know. From that day, I am entitled, my lord, at least. My lord, because that is also.
I have to say one thing. It's unbecoming of IOCL to become a coercive agency. It's almost like they're saying that we will. How is IOCL interested in an inter-se family dispute? Am I causing loss of revenue? Am I doing malpractice? Am I against?
No, you see now that issue. I
It's
think
three
maybe
times-
I think that issue might not be. I don't think you can raise it now. Maybe
Lordship,
because of the earlier judgments, orders passed by this court.
Lordship, it was on consensus. We have never, Lordship, we have every judgment of this is said as per policy. Our stand on policy is that under the policy, and it is a stand of.
And then you bring the.
There is no provision for termination.
I have
Lordship, Lordship, the maximum that IOCL can do is not reconstitute us.
1.4, my lord, I have.
That is the maximum under the guidelines they can do. And Lordship, I will show you, I had not completed. I will show you orders, marketing discipline orders. I'll show you essential commodity orders.
No.
When they can terminate.
We cannot finish this matter today.
Yes,
That's for
that
sure.
is correct. But Lordship, I have answers for everything. it is, I mean,
My
they're
lord,
not being fair. They're
in
not
fact,
being
my
fair.
lord, petitioner in one of the case, my lord, for the sake, as per policy also, he has been convicted also in one of the case in Madhya Pradesh, your lordship.
Lordship,
So as per policy, my lord, he is not entitled for
Lordship,
to
this
run
is
the.
not the suit asking for a mandamus for
have
reconsideration.
not.
No,
That's quite policy. Let me be crystallized.
you see one thing, that Gorakhpur case is not with regard to the shares who will get what, it's only
It
with,
is only that. I'll
Huh?
show your lordship. There's a schedule. Silchar and AI is there.
I have some.
Please challenge the partition deed which gives us the share. How can it not be? Lordship, in the end, what IOCL and respondent 4 is saying that forget this trial court. IOCL will now decide on the basis of evidence that they
okay,
decide.
anyway, we'll adjourn the matter for the time. Let them bring the report, no
Dealership
point.
cannot be decided by court, man.
Huh?
Dealership, who will run the petrol
he's
pump?
asking you to-
That or that petrol pump is so far as even land over which petrol pump is there. That may be my lord.
Lordship, respondent number 4 is asking IOCL and your lordship to prejudge a suit after having filed the suit themselves.
Lord. Same thing, my
It's
lord, from
unfortunate.
2014, my lord, repeatedly.
My writ petition is again termination, not for reconstitution. I will be very okay with IUCL saying that, sorry, we can't reconstitute you because there's a trial court pending. So until that happens, we will reconstitute. Let it be as it is. I'm fine with that.
20 years.
My problem is that on what law and what basis and under which policy do you terminate?
I have shown you, lordship, 1.4.
No, I'm sorry, that policy you missed. The new policy supersedes, it's expressly written.
This is the
It
scenario.
supersedes every other policy and guideline.
That is the scenario.
With the learned-
I think you all are going to take a lot more time.
Yes, your lordship.
It's not going to finish today.
Yes, your lordship.
Probably will not finish the next day also.
No, my lord, I will try, my lord, because from last
No.
10 years, my
Your
lord.
lordship, if they're coming up with some record, we should have
Yeah,
enough
yeah, he has to-
opportunity to
He has
see
to,
them.
he has to bring the report.
And lordship will give us opportunity to also see.
Adam.
It should not be that he files today and tomorrow.
Bottom of the bottom. Right,
Jesus.
heard the cause for the parties. No, this say, on the prayer of the parties, this is the matter. After 2 weeks, Mr. P. Bhadwaj, learned counsel for the IOCL shall produce all the record along with all the relevant guidelines.
Lordship, the guidelines, they could serve on us also, or it will only be for the court. Because we
No, no, everything will be given to you.
lordship,
You will give them copy also of all the guidelines,
obliged, your lordship.
right? It's supposed to be for you only or? You can charge them the photocopy
Yes, your
charges.
lordship, we will photocopy it.
We will go and
Photocopy
have a
charges.
cup of tea, my lord.
Ah,
But I am
But
not.
pleadings are not complete, he is not there. That is another problem.
no, but then that has to be heard, I think. Otherwise, because that might have a different decision.
But what is there, my lord?
No, lordship, actually subject matter are different. This is termination, that is reconstitution. No, your lordship, it's got very different connotations.
No, they are asking for reconstitution.
No, that's my.
They are asking for reconstitution.
No, no,
No, I know it's their repetition. But if we have two separate orders which are not in sync with each other, then there can be a clash between the two
Yeah.
orders. That will,
But
that
lordship,
will,
that I
that
don't
will
think
be-
pleadings are complete in that. So that is another problem.
It may not be required.
Then 2 weeks.
tag this matter along with WPC number. What is the number? Okay,
Give it to you.
this is the matter. So I will, don't put this, you throw this away. Because no point, the other matter is going to be there.
Date may kindly fix now.
Give a date after 2 weeks.
Your lordship has heard at length my.
No, I've heard, but then the pleadings are not completed. and
Other
the-
matter, my lord, I don't think.
You may not be a party there, but they will probably pleadings will have to be required.
Only for the purpose delaying, my lord. If your lordship will hear this matter, my lord, I think, my lord, whatever the bearing in that matter, my lord, will.
Okay, we'll see. Let it come together. But then I doubt. I don't know. Let's see. We'll let it be listed again together. Then we'll see.
My lord, kindly make it parted, my lord.
No, no, no. Not when I could have made it parted only solely because of this.
My lord, I
But when
think
there's
your
another
lordship may
writ
confined to this, my lord, I think, my lord, because I am also
No,
not
no.
party to that proceeding, my lord.
No, no, I understand the anxiety, but
They are also not, my lord, they are saying that issue, if, my lord, some bearing is there, my lord, all right, my lord.
no,
Your lordship may confine to this matter.
no, I will not do that. I have to be sure. I have to be sure that I can dispose it of. Otherwise, I am not going to make it parted just like
Date,
this. Give it. Okay, so this too will help it. We'll see.
Oblige
Something
the lordship.
happens.
I'll try and make a short 2-page notes recapitulating what I argued today, so it's easier.
I think that this is big Ogoish matter. When did we list it for? That, huh? No, that matter regarding that 29-8. 29-8. Because now I found my slip. I was looking for this. It has fallen on the floor. Okay.